Hi, I'm Stephanie Robinson and I am passionate about getting things right in the workplace, and I'm going to tell you about how an investigation should really look like in your place of work if you're being investigated right now. Because I believe you can tell if you're going to win or lose money at an employment tribunal or even get compensation through just knowing at this early stage whether or not your employer has done a half decent disciplinary and grievance investigation. And you know what? And this is really important. This is normally where employers cock up. Ironically, although this is so incredibly important, this is where they make the mistakes. Hi, I'm Stephanie Robinson. I have been running a business that supports employees in your situation to solve their problems in your deepest, darkest moments. I've also been an employee and I'm a HR and employment law qualified professional. And I think it is really important that at this time, when you're going through this, that you might need to consider your options, but also think about if you might want to set up your own business as a prompt, and I can help you with that as well. That's a different video, but hopefully you'll come back and have a look at some of them else. So how do you know if your employer's cocked up? Well, the investigation is, as I've said, crucial. I have seen employment tribunals be lost because the judge has ruled that the investigation was just not thorough enough. And so normally this is where you have to really point to the judge's idea that in a thorough investigation, really being independent and far-reaching enough is not going to not often fit in with an employer's agenda. So if you know what I mean by that and you're following this, then it's making sense and things are starting to click into place, type the word agenda in the comments, because the employer's agenda is really the reason often why they might lose. And imagine if this happens to you. You get a biased investigator that doesn't really do a thorough job, they've decided you're guilty, and it's basically just a half-arsed attempt at an investigation to push you through to disciplinary. Or perhaps a witness stretches the truth because otherwise it looks bad on them. And well, they don't like you anyway. So a shoddy investigation can mean you can lose your job, lose your livelihood, have a warning on your impeccable record, or you can then spend months, even years trying to clear your name and make sure that you're treated fairly. Or the point that you make is that you've been untreated fairly and people that come after you are not treated in the same way. It might mean, as I've alluded to, the start of a new beginning for you. I'm happy to talk that through in a different video. But I have seen it from the other side. The botched investigations because employers and the management have their own agenda. As I mentioned earlier, they're not willing to be fair and listen. And I have personally wasted thousands of pounds of money on legal fees, not in this situation all the time, but lawyers very rarely help or are useful at this point. But this is why I've established HR Solver, to even out that playing field, readdress the balance and allow everyday people to protect their jobs and livelihoods without going to a lawyer and paying thousands, but also to show an alternative option of how you might get compensated if this situation does go wrong, so that you then do have the freedom to start your own business or do whatever you want, take a break, pay some mortgage off, but have the balance of financial assistance and support for an interim period. And to do that, it's essential you understand this investigation process and how an investigation, if you're being investigated into misconduct, should go. So I'm going to talk to you about what a proper disciplinary investigation looks like. I'm going to talk to you about the approach your employer should take to witnesses, pulling the reports and evidence together. And I do know this is hard. I know this is really hard on you right now. And would like you to think that an investigation shouldn't already and often always mean that you're going to a disciplinary hearing. The employer needs to remember this as much as you do, the option for there being no case to answer as a result of the investigation. That the investigation is purely fact-finding to make a judgment on whether there's a case to answer or based on establishing the facts through fact-finding. And if there is, and what potential violation might that be measured against. So let's take the who, what, when of an investigation first. When starting the investigation, the appointed investigator from your employer should really be independent. And what I mean by that is that someone that's maybe from a different department that doesn't know you, you don't know them very well, but most certainly hasn't been involved in the incident or allegations against you. They've not been a witness, they weren't the first people on scene, and if they were and that was your manager, it certainly shouldn't be your manager doing the investigation because they are arguably a witness. The investigators then should or will interview you first. They should be hearing your version of the events. Sometimes they might have to come back to interview you again, so you get 2 interviews as part of just an investigation. And that is probably a good thing because they're truly trying to establish the fact finding. And again, the interviews shouldn't be accusatory like a police investigation on telly. It's about you being asked decent questions. Untrained managers sometimes get a bit carried away. They think the power goes to their head and they make closed questions. They're trying to trip you up. They're trying to pretend that they're the police. And if this is the case and it gets out of hand, stop the interview immediately. Say that you have concerns about the way that this is going. It's not independent to your mind, and immediately email HR or any other person senior to say you have concerns about how the investigation is being conducted. If the interview goes okay and the interviewer and investigators know how to do it properly, then you're looking at the evidence and the who and what and when it closes off. The ACAS Code of Conduct states, and employers should be following this, that an investigation should be concluded and dealt with properly. Issues should be followed without unreasonable delay. This means delays to meetings, decision making and confirmation of decisions. So your investigation should not go on for months and months whilst you either sit at home suspended or even in work worrying if there's going to be action taken against you. The longer the case is unresolved, the stronger, ironically, your case might be for unfair dismissal, poor treatment. And so I would normally expect, as a measure, an investigation to be wrapped up in the most 3 to 4 weeks. If they can, you do also wonder the quality of the evidence that they have. Before I come to the evidence, the second important part of the investigation is witnesses. So if there were witnesses in your case, they should really be interviewed, and your employer should be trying to conduct as detailed an investigation process as possible. Like your own investigatory interview, that witnesses shouldn't be led. They should just state the facts of what they saw. They should not be asked opinion about you and your professional life. It should be specifically to any incident that they're investigating. And these interviews should be typed up, minuted. The witnesses should be asked to sign and date their statements. And if it's a contentious matter, it might be that the witness has asked to stay anonymous. And this can be the case where you're presented with anonymous statements. And I'm going to talk about how you deal with them shortly. But you can certainly ask that they are not considered as valid in the overall investigation and conclusions because you can't verify that evidence personally. But before I talk about the importance of evidence, I want to give you some information on how, if you're struggling to know whether or not you have a strong employment tribunal claim, how you can get a clarity on whether you're the strength of your claim. So if you want to go to the HR Solver website, it's hrsolver.co.uk, you can get a totally free guide which will help you determine if you have a strong claim at Employment Tribunal. There's a link below. You can get this totally free, and it talks you through, it's quite a comprehensive document, and it talks you through 9 clear questions and answers with minimal legal jargon. Truly, you do not need to be a lawyer to read this and get the essence and answers you need. And it will tell you about your legal rights and the strength of your tribunal claim. But now I'm going into the evidence in an investigation. Any investigation report, which should normally be produced with conclusions and recommendations, a letter inviting you to the disciplinary hearing, and all the evidence should be sent to you in advance, and at least 48 hours in advance of any meeting that you're being summoned to. There should be no evidence coming out from under the table in the disciplinary hearing, or worse still, I've heard of new evidence being produced in the appeal stage. And that is not the purpose of the appeal stage at all. So do not tolerate that if that happens. If there's references to text messages, even if you've supposedly sent them, they should be photographed and included in the copies of the witness evidence sent to you in advance. It should be nicely printed out in a package so that you've got it, that you can bring it into the meeting. And the whole point of the disciplinary hearing, remember, is that you're then given a chance to respond to these allegations. If you don't have this evidence in advance of the disciplinary, how are you supposed to do that? Similarly, if there's CCTV evidence or camera footage that they're going to refer to it, you should be invited in advance to watch that evidence of the hearing, normally a day or it could be an hour beforehand. If there's statements from witnesses that have asked to be anonymous, if the case is clear that you don't want that evidence included, because you can't defend yourself against that evidence, then make that the point. Say that you don't think it's just or it's fair of them to include that when you don't know who've made these allegations against you. So ask that to be removed for the investigation. They may or may not, depending on the validity of the evidence, but it's worth asking. If you want to know about your rights and you're going through a tough time at work, watch the next video, which is just here, where I talk about how to appeal and write a compelling appeal letter if you've been dismissed for disciplinary or even redundancy. And if you have liked this video, please subscribe. Please let me know that this is helpful. Even drop me a note in the comments below of any other content you'd like me to make, and I'd be delighted. All the best, and I really hope that the investigation is fair and you don't get to the disciplinary stage. But if you do, I'm here to help.